Good morning.
Morning. Mr. Chief Justice, Associate Justices, may it please the Court, my name is Edward Weitzel, and I represent the appellee in this case, who is also the petitioner for further appellate review, Henry C. Becker Custom Building, Limited. The question here today has to do with the applicability of Section 23 of the Workers' Compensation Act, and the appeals court has decided in this case that it is limited in the same way that the immunity provisions of Section 24 are limited to direct employers, those that directly employ the employee who is entitled to benefits. The problem with this argument is threefold. That's not what Section 23 says. It's not what the legislature intended it to say. And this court has said any narrowing of the Section 23 is a public policy decision for the legislature and not the courts. For these three distinct reasons, we would ask that the decision of the appeals court be overturned. Starting with the plain language of Section 23, Section 23, which is a release provision, which provides that when an employee accepts benefits under Section 20 or under the statute, Section 26, Section 23 operates as a statutory release of the claims that he may have against the insured. And the key thing here is that the word that's used in Section 23 is the insured. Further counsel will point to the definition of the word insured, which is found in, I believe, Section 1.6, which talks about how an insured is someone who provides or carries workers' compensation insurance for his employees and for payment to his employees. And that is the basis for the statutory construction argument that my brother counsel makes regarding 23's limitation to direct employers. I would submit that this language does not indicate any kind of causal nexus between the employee and the insured. All right.
Let me just ask you this: I want to see if I have this right. If there were a nexus, would it be your point that under Section 18, your insurer should not have paid for the two Wentworth, in connection with the two Wentworths' death and injuries, respectively?
I'm not sure what you mean, Your Honor.
Well, Section 18 talks about the insured person, which would be Becker in that instance, correct? Yes. But obviously the Wentworths weren't your client's employees.
No, they were not.
So I'm just asking whether it follows from the way that you're saying insured isn't limited to insured for your own employees, correct?
Yes. My argument, and I think Judge Billings in the Calendar case, which is a trial court decision, I think Judge Billings said it the best. He said, when he said that clearly the plaintiff is an employee of someone, and the defendant is an employer of someone and an insured who's carrying workers' compensation benefits, there's no direct connection required by Section 23. The direct connection that's found in Section 24 is required by operation of an amendment to Section 15 of the Act, which involves third-party claims, which was adopted by the legislature in 1971 to abolish the Common Employment Doctrine. The Common Employment Doctrine was a doctrine that said that the carrying of workers' compensation insurance by one of the employers on a job site would throw its shadow over the whole work, such that everyone on the job site that was related to that would be immune from liability under Section 24. All right. That provision uses specific language which says, and I'll quote it directly here, it says, "Nothing in this section or in Section 18 or 24 shall be construed to bar an action at law for damages for personal injuries or wrongful death by an employee against any person other than the insured person employing such employee." Mm-hmm. That's where the direct causal, the nexus of direct employee status comes in for Section 24. It's by the operation of this language. This is what got rid of the common employment doctrine, and this is what created the requirement under Section 24 that there be a direct employment relationship in order for immunity to attach.
But doesn't it, I mean, it just doesn't make sense, does it? In other words, that a direct employee who gets workers' comp from his employer has a right to bring an action against a third party,
Yes.
but an indirect employee doesn't.
I'm sorry, I'm not sure I understand.
Well,
Under which section? 24?
23, as you read it.
Oh, under 23, the direct employer would already be immune.
Yes, but under 23, in this case, your client is the third party, correct?
Well, my client would be a third party under application of Section 15, 18, and 24 for the purposes of the immunity question.
Right.
He is not immune, or his
Right.
company is not immune from liability under Section 24. The question is, once the plaintiff has chosen and elected to take workers' compensation benefits, the question is whether or not that act has then released my client from claims under Section 23. It is the affirmative act of accepting the benefits, filing a claim, accepting the benefits, that triggers Section 23, as opposed to the Section 24 immunity, which exists by dint of the carrying of workers' compensation insurance.
But let's think of how this is supposed to work. Step back a little bit. You're an employee of a subcontractor. Your subcontractor has been hired by a general contractor. The subcontractor is in compliance with the law, has workers' comp insurance, and you're injured. You get workers' comp insurance through your subcontractor, and you can sue the general contractor for liability if there's some negligence.
Common law tort case.
So that's how it would ordinarily work.
Yes.
Here, and so why shouldn't we view the intention of the legislature as to put that employee in the same position if a general contractor should hire subcontractors that are not insured? And that is, A, the general contractor will take on the obligations of the subcontractor to provide workers' comp coverage and is still liable as he would otherwise, or it would otherwise be under for negligence.
Yes, Your Honor.
Why shouldn't we view that as the legislative intent? And can't we read the statutes that way?
Because they did not do that. When they put the direct employment relationship requirement into Section 24, they didn't make any reference at all. Conspicuously absent from that amendment was any reference at all at Section 23. I don't think we can read intent into the amendment of the 1971 amendment of the statute that they intended to put Section 23 in there when they very well could have done so, and in fact have since, in 1985, rewritten Section 23 and not taken the opportunity to amend it at that time or to add it to the language of Section 15. So I think it would be a stretch to assume that the legislature intended to include Section 23 in this limiting language that restricts immunity under 24 to direct employers.
But to take Justice Cordy's point, you would agree that the purpose of Section 18 is to encourage contractors like your contractor, like your client, to subcontract with companies that have workers' comp insurance.
Well, I would suggest that the main purpose of Section 18 is to ensure that the employee has workers' comp coverage.
But, I mean, isn't there a case, and I'm not going to remember what it is, that talks about that is the statutory purpose?
Well, that is one of the reasons for narrowing the scope of 23 to direct employment relationship would be to encourage the general contractors to hire an insured sub.
I'm not talking about the appeals court decision in this case. There's an earlier case, is there not?
I believe there was, in fact, I believe it was a case written by Justice Gantz.
No, an appellate decision that said the purpose of it had nothing to do with this. Just
Okay.
The purpose of 18 is to encourage general contractors to use subs who have workers' comp.
Yes, that is in one of the appellate
Okay.
decisions.
So if one assumes that that is an important purpose, if not the only purpose, your interpretation runs totally contrary to that, because someone like your client is much better off employing subcontractors that don't have insurance because there's, under your reading of 23, there's absolutely no way that your client can have common law liability.
Well, I would respond, Your Honor, respectfully by saying I don't agree that my client is always much better off, or that someone in a similar situation, my
I don't
client.
mean to say there's an intention here. I don't mean that. But, I mean, isn't somebody better off having non?
No, Your Honor. I would argue that that's going to depend on the case, because there may be many cases out there where now he has to pay no-fault liability in an instance where he may not have had any liability at common law. So in this case, it's hard to tell at this point, but it's essentially the purpose of the act is to trade the right to defend yourself at common law as an employer, all right, in exchange for a payment of no-fault liability that may not be as much as you may be exposed to at common law. And what Section 18 is doing is imposing that on the general contractor where he fails to hire an insured sub. So in this case, he's stepping into the shoes of the employer. He's taking on the mantle of carrying the workers' comp coverage. It's his insurer that's paying out the payment. And in exchange for that, he doesn't get immunity. He does not get immunity because he's not a direct employer. But our argument is that he should get the release provision should the plaintiff accept to take those benefits. And I think that's important, which is the plaintiff has a choice. The plaintiff can still sue if the plaintiff chooses not to accept the benefits. The plaintiff did not have to take the benefits here. And I think that's an important distinction between 23 and 24, and maybe one of the justifications, frankly, for why the two should be read differently is that in Section 24, the immunity attaches by dint of carrying the insurance, whereas in Section 23, the immunity is only triggered by the, not immunity, but the release is only triggered by the acceptance of the workers' comp benefits. And I would say one other thing about that policy argument about encouraging employers to hire insured subs. That may very well be a justifiable policy argument for changing the statute. But I think this court has said in looking at 23 that this is a broad exclusivity provision and that the legislature intended it to be very broad and has had opportunities to narrow its scope and has not done so. And that any narrowing in the scope of 23, and albeit in the Becker case it was a slightly different scenario, but it was still Section 23 in play, any narrowing of the scope of Section 23 is a decision for the legislature. So while I might agree that there are some policy decisions or policy arguments that are in play here, I think that that's a question for the legislature to resolve as it pertains to limiting the scope of Section 23.
We are trying to find out what the legislature intended in statutes that are obviously ambiguous, and so understanding the policy goals behind the statutes and their amendments is helpful in that regard. Not that we're making an independent policy judgment, but
yes, Your Honor.
To us.
But I would suggest, and my primary argument would be that the statute is not actually ambiguous, that it's fairly clear that it applies to an employee and an insured, and that Mr. Becker wasn't insured here. He carried insurance for his employees, as that's defined under the Act. And the Wentworths were employees. They worked under a contract for hire. Therefore, I think the statutory language is fairly clear. But even to the extent that it is ambiguous and you need to look to the legislative intent, I think that the failure of the legislature to include Section 23 in the amendment of 1971 is very telling about what their intent was. And I actually think that it makes common sense when you think about what other purpose Section 23 would serve. If it were limited to direct employers, it would be tough to think of a situation in which those direct employers wouldn't already be immune from liability by dint of having the coverage. It would seem to render the statute superfluous. And I cannot think of, off the top of my head, and I'm not claiming to have thought of all the scenarios, I cannot think of an example where a direct employer would be in a situation where it would have to rely on the release of liability from the grant of or the acceptance of workers' compensation benefits who wouldn't already be directly immune under Section 24.
Well, I can't think of all those scenarios either, but certainly one of them, and I guess we know by experience that this is not common, but it certainly could be common, and that is employees choose to retain their common law rights at employment. Years later, they are injured on the job, and they are offered the opportunity to accept unemployment compensation benefits by the company rather than bring suit. And if they do, then they waive the claims. I mean, that's not illogical.
And that's not illogical, Your Honor, but I think that would be a rare circumstance where someone opted at the beginning of their employment not to be eligible for workers' compensation benefits, that they would be offered and accept workers' compensation benefits later in the game. But I suppose that is something that could be.
Bringing a lawsuit is can be a very long journey. You don't get paid while the lawsuit is pending. Maybe you win, maybe you lose. Unemployment compensation is dependable. It's there. It's got a lot of benefits.
Understood, Your Honor. I see my time's wrapping up. If I could just sum up, this court recently in the Saab versus CVS pharmacy case, which is not in the briefs, it's a 2008 case, which was decided after the briefs were submitted to the appeals courts. These obviously are the appeals court briefs. Said that it is not the role of the courts to create a more comprehensive or logical scheme of compensation. And then in that case, they were talking about Section 24, but I would argue that even if the public policy arguments are accepted by this court, it's not the court's role to adopt those public policy arguments by changing the statute, and that the statute says what it says on its face. And given the plain language of the statute, the purpose and intent, the failure of the legislature to include Section 23 in the amendment, and that we believe that the appeals court's decision should be reversed.
Thank you, sir.
Thank you.
Good morning. If it pleases the court, John Frazier. I'm here on behalf of the appellant, Cheryl Wentworth, as administrator of the estate of Timothy Wentworth and as guardian of Ezekiel Wentworth. And we are asking that the court affirm the decision of the appeals court.
So what's the purpose of 23?
23, I would think, is, just as you noted, the situation where if you had a case where a employee opted out of workers' compensation rights at the beginning of the employment, and then at some point down the road is injured and decides, hey, it's better for me financially at this point to take some workers' comp benefits as opposed to a tort suit, and he accepts it. There could be a situation like the case that is cited, Niskanen versus Malconian, where someone brings a comp claim, the employer says, you're not our employee, you're an independent contractor. They also have an independent tort suit. He decides to accept some money under workers' comp. He takes a small lump settlement. In that case, he tried to reserve his rights to continue with the common law claim. The court said, no, if you accept under that situation, you're basically alleging you were an employee when you file a workers' comp case. In that situation, 23 releases the employer.
But the excuse me, the construction that is being argued by Henry C. Becker, which seems to me, look, it treats the Becker exactly the same. Its response as if they were its own employees. If these were its own employees and it had to pay comp for them, they couldn't sue it. And so since under 18 it has to pay comp for them, they shouldn't be able to sue, and that's what the last sentence of 23 means.
But I think if you look at Section 15, which specifically addresses third-party actions, and most importantly, as the appeals court noted, the amendment in 1971, the specific language says, nothing in this section referring to 15 or 18 or 24 shall be construed to bar action by any employee against any person other than the person employing the employee and liable for payments under 152.
But it doesn't reference 23.
It doesn't reference 23.
It says, but you're saying
since
they're getting the insurance under 18,
they can still
18
sue
doesn't bar them.
15 covers. Becker's in here because of Section 18. That's the only reason they have to pay. 15 allows me to bring a lawsuit on behalf of the Wentworths. 15 says, nothing under 18 prevents you from filing a suit against anyone except your direct employee who paid you workers' comp insurance. And if you look at the statutory definitions, which are important under Section 1, insured, an employer who has provided by insurance for the payment to his employees by an insurer of the compensation provided for by the statute. Clearly, Becker was not an insured as in relation to the Wentworths. Clearly, Wentworths were not employees of Becker. No one is debating that. So clearly, they don't fall under that for statutory purposes. And then when you look at the way 15 and 18 interplay, it's clear the legislator intended in situations where a general contractor has to fall down because they hired someone who didn't have a workers' comp insurer, and they have to pay under 18, the employee can still sue them because they are not their direct employee and they were not responsible to pay them workers' comp.
And 15 makes clear that 18 doesn't interfere with their right.
Doesn't interfere. And the case you were referring to, Your Honor, was Tyndall versus Denholm and McKay. It's a 1964 SJC case which says one of the purposes of 18 was to give general contractors incentive to go out and check out who they're hiring and to hire subcontractors that have workers' comp insurance. And I think it's important to be mindful that in this situation, if eventually we're successful in our third-party claim against Becker, the insurance company gets paid back everything under Section 15. So there is no double recovery for the Wentworths because the insurer steps in first. They get everything back under the statutory lien. If you went with Becker's interpretation, my people are left out of an opportunity to pursue a common law claim for a lot more damages. Workers' comp, you got 60% lost wages, medicals, very limited for scarring, disfigurement, that sort of stuff. Tort damages are far greater. And also, as you pointed out, Justice, it gives general contractors an incentive to hire subs who don't have workers' comp. Then they're immune from tort liability, which obviously you have to prove negligence and all that good stuff, but the potential for a larger judgment exists under a tort setting than in the workers' comp world. So I would think that when you look at all those things, and it's pointed out in...
Well, they wouldn't be immune from tort liability. Presumably, the employee doesn't have to accept the benefits. And then right?
Right.
The employee doesn't have to accept the benefits and can sue the general. Under the other...
Under the other scenario, but
Yeah.
the reality is most people, working people, they got families, they got to accept the money, and the workers' comp statute traditionally is designed to protect employees. They give up certain rights, but I think the most telling thing here is obviously the 71 Amendment. Section 15 governs third-party claims. Section 15 specifically says nothing in 18 prevents a third-party action against anyone except your direct employee who paid you workers' comp. And there's case law. It is the Lang versus Lamont for immunity. There's traditionally a two-pronged test. Employer insured for liability payments under 152, and the employer must be the direct employer of the employee. We don't have that situation here. I think the appeals court decision was well-reasoned. It balances out everyone's role. It preserves the employee the right to bring a third-party claim that they may be able to prove.
Decision, correct me because I read it over the weekend, now I can't remember. Does it really deal with this last sentence in 23?
It doesn't address it specifically, no. It just says that they read it, the immunity in 23 kind of running hand in hand, that when you look at particularly amendment to Section 15, the definitions of who is an insurer, who is an employee, and the case law holding that one of the purposes for 18 was to give an incentive to hire subs with workers' comp, that when you look at all those things, that clearly it was the intention that a claim such as this be allowed to proceed, that accepting benefits under 18 does not preclude the employee from bringing a third-party claim against a general contractor under this scenario. So, that's all I have, unless there's some questions.
Well, thank you very much, Tom.
Counsel.
Thank you.